Today, I'm delighted to introduce our speaker, Erin Joyce. Erin Joyce has extensive experience in state bar investigations and disciplinary proceedings, plus over 30 years of civil litigation practice. Erin was admitted in 1990 and practiced for nearly 8 years in an intellectual property boutique before joining the Office of Civil Chief Trial Counsel as a prosecutor for the state bar from 1997 through 2016. Erin has over 25 years of experience handling all aspects of discipline cases against attorneys in state bar court, from the filing of the complaint through trial and review. She has personally tried dozens of state bar trials and several appeals. Erin has a comprehensive understanding of how state bar investigations and proceedings unfold. Before going into private practice, Erin served as Chief Special Investigator for the Los Angeles Fire Department, as a prosecutor for the State Bar of California, and as a lawyer for multiple private practices. And now, without further ado, let's get started.
Okay, all right, so let's go to the next slide. So basically today we're going to be talking about, what I think all of us licensees have been around for any length of time know as CTAPP, or the Client Trust Account Protection Program, which for the last 3 years, all licensees of the State Bar of California have to have certified full compliance with. So we're going to talk today about, you probably all know basically what CTAPP is, or at least the first phase, which was the registration and self-assessment, making sure people were in that educational phase of like figuring out how and making sure that people are properly administering their trust accounts. Now we're moving into phase 2. That's underway right now. That is the CTAPP compliance period, where from this point forward, there are going to be annual compliance reviews conducted by the State Bar's Division of Attorney Regulation. And we're going to talk about, basically this is all rolling out, and clearly there will be some changes along the way. So we'll talk about some updates and concerns that have been raised about, especially this phase 2, the compliance reviews. So next screen. Okay, kind of touched on this. Back in 2023, the Board of Trustees of the State Bar established this Client Trust Account Protection Program. And the whole point of it is to protect client funds. And I say client funds, but really that's a misnomer. It's any type of funds entrusted to a lawyer. So the fact that they may not be client funds, but other third-party funds, it still would fall within the rubric of CTAPP. Basically, any funds that are entrusted to the handling by a licensee are going to be covered by Rule of Professional Conduct 1.15. Now, the adoption of the Client Trust Account Protection Program back in 2023 was not creating a new requirement for lawyers. There has, long been a requirement to properly handle entrusted funds. And while the Rule of Professional Conduct, up until the current iteration of 1.15, talked about a client trust account, and in fact, even this program talks about a client trust account, case law, even before the adoption of the current rules, covered when a lawyer is holding entrusted funds for a third party. A classic situation would be when you have, like in a family law case, the house sells, but the two sides haven't come to a full agreement under a marital settlement agreement. So that means there's money that belongs potentially partly to the wife, potentially partly to the husband. Who's going to hold that money once escrow closes? That money is entrusted funds. And even prior, like I said, to 2018, when the current rules were adopted, the lawyer has the same fiduciary duty over those funds, both to his or her actual client, the wife, as well as to the husband. And there's a series of duties that lawyers and licensees, as the State Bar likes to call us now, we're no longer members of the State Bar, we're licensees of the State Bar. We have certain obligations and duties when we, take possession of entrusted funds. And two of those, which have been changed by CTAPP and made more stringent, are your duty to account, your duty to promptly pay out, and your duty to notify receipt of funds. And if you take a look at the current Rule 1.15, it has a laundry list of your duties when you're holding entrusted funds. So the purpose of why CTAPP was adopted, I think all of us know, unless you've lived under a rock, it is really in the wake of the Girardi scandal. Basically, it came out once Tom Girardi was found, not in California, but in an Illinois bankruptcy court, to have misappropriated hundreds of millions of client funds over a lengthy period of time. It came out that the state bar had closed more than 100 complaints about Mr. Girardi's handling of funds, and only one of them resulted in any discipline. Actually, three cases had been rolled into a private reproval that never became public. And the state bar, through a series of efforts of the LA Times and other media, was forced to actually provide further insight into how these cases, that many of which talked about missing funds from clients, never resulted in any discipline. Let's go to the next slide. So basically, CTAPP was ushered in as the state bar getting serious about proper trust accounting by lawyers. The first phase of CTAPP, to protect the public and ensure that lawyers are handling entrusted funds are doing it properly, would be to make sure that all the trust accounts in California are registered. And actually, many of the trust accounts were not registered up until very recently. And starting in 2026, now the financial institutions have to have at least one licensee registered to the trust accounts that they maintain. Up until these latest changes, there really was no way to, cross-reference a lawyer's trust account with what account might be at a financial institution. So the purpose of CTAPP was, again, public protection. Also, another very important part of CTAPP, Client Trust Account Protection Program, was to educate lawyers to ensure that they understood what it meant, what it means to properly hold entrusted funds. And in my experience, most lawyers who, working through the last 3 years of having to certify full compliance with CTAPP under penalty of perjury, at minimum, when an attorney is certifying compliance with CTAPP, that means to the penny, you need to know how every single dollar in that trust account is distributed among multiple claimants, clients, and others. Let's go to the next slide. Okay, so in ushering in the Client Trust Account Protection Program, there were some changes to the rules of court and to the rules of professional conduct. The first change, anyone that's been a licensee since 2023 knows there have been 3 years of annually reporting CTAPP compliance, and that's required under California Rule of Court 9.8.5. You also have to annually certify your registration of any trust account for which you are either the responsible attorney or the signer. And if you're in a firm that maintains a trust account through agency billing, lawyers can affirm that their law firm, through the managing attorney, has confirmed of CTAPP compliance. Lawyers for the last 3 years and going forward have to annually take, varying self-assessment classes, questions. This last year, there were 14 questions. And these questions, over the last 3 years have been modified, made more streamlined. I could tell you the very first year, I would be on, webinars or meetings with some of the best ethics lawyers in California, trying to figure out what in the world they were asking for on some of those questions. Now, the most important part of your CTAPP compliance is at the very end, there's 2 boxes that you check. You check that all of the information that's provided is true and correct, and that you're doing it under penalty of perjury. And why that is so important is that that's a representation to the state bar. And a licensee who is found to have made an intentional misrepresentation to the state bar engages in moral turpitude conduct in violation of Business and Professions Code 6106. So in addition to whatever trust account violation that may be uncovered based on some other investigation later on that arose during the reporting period for which the lawyer has certified under penalty of perjury that they've fully complied with CTAPP. If it turns out a later investigation shows that that lawyer, in fact, wasn't fully compliant with CTAPP, the State Bar prosecuting arm, which is the Office of Chief Trial Counsel, can pursue additional very serious charges for moral turpitude. Now, if you have questions going forward, we have a Q&A feature here. I think the chat has been disabled. But if you have questions, I am happy to take questions at the end. But if there's a question that you think, as we're going through, needs to be answered now, or you have, go ahead and put it in, and then I can answer it if it makes sense to do so now, or I'll try to hit the questions at the end. So let's go to the next question. Next slide. Now, if you're not sure that you're in compliance with CTAPP, it's not that hard to find out. The truth is, 3 years ago, there were lawyers that had never accessed their State Bar profile electronically. Mostly older lawyers, honestly, because up until the last 5 years or so, many lawyers still relied on paper statements. And if you processed payment by check in a paper statement, really, you may have never had cause to check your State Bar profile. I can tell you now, absolutely, you should have access. And probably if you're in compliance with CTAPP and you've been going re-registered and paid your licensing fees for the last 3 years, you know your State Bar profile. There's more and more information that's required to be reported on your State Bar profile. You could see it on the landing page. If there's anything that's missing, it'll show up as red and non-compliant. And right now, if you were not compliant for this year, you wouldn't be on active status. So I'm pretty confident you've all been able to check your State Bar profile and made sure that you've certified, under penalty of perjury, that you're in compliance. The problem is if you're not in compliance, what's going to happen? Let's go to the next slide. Okay, what does non-compliance mean? Non-compliance is failing to satisfy all of the requirements of Rule of Professional Conduct 1.15, which concerns the safekeeping of entrusted funds, and the specific requirements of the Client Trust Account Protection Program by the required deadlines. Now, there's two different courses of action within the Office of Chief Trial Counsel and the Office of, or the Division of Attorney Regulation within the State Bar that take place based on noncompliance. One is the regulatory response of the agency to the noncompliance, and the other is potential discipline. And they're not mutually exclusive. But in the first instance, noncompliance is much more quickly dealt with in the administrative procedures. And that is, you have the Division of Attorney Regulation. If you had not certified compliance with CTAPP by the deadline, I think it was back in April 3rd, because of the weekend that intervened, you got a notice through your State Bar profile of assessing a non-compliance penalty and inviting you to get into compliance. If you remained not in compliance as a licensee, the Division of Attorney Regulation issued a notice probably about a week into July, which says effective as of July 1st, you're enrolled on administrative inactive status. Now, I have clients that, for one reason or another, had both of those concerns happen. And then you have to get back into compliance. And you might think, wow, that was hard, but I've done it. That does not in any way resolve what might be attendant discipline, which is all handled within the Office of Chief Trial Counsel. The Office of Chief Trial Counsel is the investigative and prosecuting arm of the State Bar. Let's go to the next slide. Okay, I'm just going to hit this. There are certain, as of now, classes of attorneys that don't have to comply with CTAPP. If you were never on active status anytime in the reporting period, you don't have to do any report. But if you were active even a day during the reporting period, you have to comply. Again, if you're on not entitled to practice status, you don't have to do CTAPP compliance. If you're enrolled as a multi-jurisdictional practitioner with the State Bar, there's no need to require CTAPP compliance. And anyone else that's not exempt from the requirements must comply with CTAPP. Let's go to the next slide. Okay, now for the last 3 years, as the State Bar has worked out its bugs in the screens for the State Bar profile for CTAPP compliance, and they've gotten, honestly, increasingly more user-friendly over the time, including agency billing screens. That was the first phase, is getting all of the trust accounts registered. And again, there's more than one type of trust account. There's, and we'll talk about this a little bit later, there's general IOLTA trust accounts, and then there are lawyers that have individual trust accounts. So the first phase of the adoption of CTAPP was to require these annual registration, annual assertion of conformity with CTAPP. Now we're in phase 2, reviewing compliance. And that is, going forward, we're going to be having compliance reviews. Now let's go to the next slide. Okay, so what to expect and what's actually underway now. As of the September 2025 Board of Trustees meeting, the head of the Division of Attorney Regulation, Steve Moad, made a report. And his report was that, now having spent the last year with voluntary audits of trust accounts, now the Division of Attorney Regulation was ready to start the actual compliance reviews. And the plan, which we'll talk about, was started at the end of September of this year. So the expectation is that there will be a certain number of these compliance reviews. The compliance reviews, depending on what's uncovered with respect to the reviews, will initiate a certain number of investigative audits, again, conducted within the Division of Attorney Regulation. And then there'll be issuing of mandatory corrective action or referral for discipline. That's all coming out of this growing area of the State Bar, the Division of Attorney Regulation. That's the same folks that do the, updating your State Bar profile, and also all of the registration for professional law corporation and the like. So that's a growing area of the bar. So, within the bar. So let's go to the next slide. So early this year, the State Bar rolled out compliance review and investigatory audit procedures, which now have been adopted by the Board of Trustees. And we're going to look at those in more particular depth now. Let's go to the next slide. Basically, in order to comply, maybe I should back up. How did the office or the Division of Attorney Regulation come up with calibrating for these, soon to be started and actually underway now, compliance reviews? You might recall last summer in 2024, every licensee got an email saying, hey, do you want to be a guinea pig and get audited by us? Because within the Division of Attorney Regulation, there's a team of CPAs that are now on staff with the State Bar, and they are the ones, along with selected CPA firms throughout the state, would be helping do these voluntary compliance reviews. 300 law firms or lawyers volunteered for the compliance reviews. And I would imagine, I had clients call me, hey, should I do this, Erin? And my answer was absolutely no. Do not do that. Why open yourself up for review? You don't know what they're going to find. Of course, you think you're doing everything right, but why would you do that? The only people I would say that made any sense to volunteer for that prospect would be those that could get a benefit, like me, as an example, which I did not volunteer. But it would make sense for someone like me to do that, because then I could see from the inside how these audits were conducted. But generally, there were 300. And of those 300 volunteers, 20 voluntary audits were conducted by the Division of Attorney Regulation. And they were working not just with the CPAs on staff, but also with outside CPAs, because the state bar at the same time was soliciting proposals from CPA firms throughout the state who were wanting to make their way onto the panel of approved auditors that will be working with the state bar with respect to the compliance reviews. So having completed those 20 random, I guess, voluntary audits, state bar through the Division of Attorney Regulation now feels and is underway doing the compliance reviews. One thing that they reported, and this was in the Daily Journal a couple of weeks ago, that in doing these voluntary audits, they found 89% non-compliance and the need for corrective action. 89%. Now, if you think about who's going to be even volunteering for this, these are the people that sit in the front of the class all the time, hands up, really, really, really want to volunteer, really want to look good. I would imagine no one would put themselves out to be audited voluntarily unless they thought they were squeaky clean. But nevertheless, even out of that cohort of voluntary folks that got audited, there was an 89% non-compliance rate. So, query what they're going to see from the hapless 100 that they're selected for this year. Now, once you are selected, or if you've been selected, in order to comply with this compliance review process, the first thing that happens is that the licensee has to designate an approved certified public accountant to conduct the review at their own expense. The only way you can get out of having to pay, for this audit is if you gross less than $150,000 for the reporting period. So if you gross less than $150,000 in 2024, then you can file a request to be audited by the internal CPAs on staff with the Division of Attorney Regulation. They don't even have to agree to that. But assuming that exemption is granted, then you don't have to use one of their captive or preferred CPA firms. But anyone else has to do an audit through one of the selected, the selected members of this list, CPA firms, to do the audits. And if the licensee is selected, the licensee or their firm becomes subject to requests for information, requests for responses to actual questions, and has to comply with all the mandatory corrective action plan that's issued in conjunction between the outside CPA firm and the internal folks at the Division of Attorney Regulation. We have yet to see these actual mandatory corrective action plans, but they're going to be imminently available, I would imagine. Let's go to the next one. So from what I've seen, the plan as enunciated at the September 2025 Board of Trustees meeting from the head of the Division of Attorney Regulation was that starting at the end of September, there would be 100 law firms or lawyers that will be subject to a compliance review, 20 a week. And from the calls I'm getting, that seems to be actually occurring. So 20 licensees for 5 weeks in a row are going to be getting this email inviting them to participate in the compliance review. They have to, within 30 days, they have to provide the names of everyone who's the designated licensee in charge of that trust account. They have to open up on this special portal all the information about the trust account that's being audited, or if you have more than one trust account, I would imagine all the trust accounts for which you're identified or associated, either through your own state bar profile or through agency billing. You have to comply with all of the requests for information and answer all the questions that are posed by the auditors or staff of the attorney regulation. You have to provide all the records. And you have to submit acknowledgement of the receipt of findings within 14 days. So we're at the early stages here, so we haven't seen the last few of these steps yet actually roll out. Now, I'm going to answer a couple of the questions. Let's go to the next slide, but in the meantime, I'll answer some of the questions that have popped up. One is, what effort is being made by attorney associations to have the bar change the rules so it's less burdensome? I'm not aware of of those kind of efforts, but I do think as you start seeing how this is going to really impact, especially solo and small firms, with just the financial impact alone, that's certainly something that should be taken up. How can I see if I'm in compliance? You go in your State Bar profile. If you see like a red box around your CTAPP compliance, that is where you're going to definitely want to know you're out of compliance. You'd already be on inactive status for this year if you didn't certify CTAPP compliance. And you have to register every single trust account that is associated with your practice. So there's no limit, like only one. If you are a family law lawyer and you're still, stepping in and holding entrusted funds like the sale of the house, which I strongly suggest you not do. But if you do that, that belongs in an individual trust account that you need to register within 30 days of it being set up. So a lot of really savvy family law lawyers that I know now, instead of what they're doing, instead of putting this kind of funds in a, interest-bearing individual trust account, they have the two claimants to the funds, the husband and wife, set up an escrow account. That way it's not administered. It's not funds held by the lawyer. And that way it saves the lawyer from, pretty onerous CTAPP compliance, which, by the way, you cannot bill an attorney, you can't bill attorney time for your CTAPP compliance work related to an individual trust account. So that's probably the best approach because it does take administrative and attorney time to do this. Okay, so here's a question. For licensees who are employed by law firms, which hold the entrusted funds, what are the best practices for employers and employees to be prepared for audits and compliance reviews? For example, should the licensee obtain a statement in writing from their employers regarding the CTAPP compliance? Yes, I would say, and this is true even before the audit started, if you're part of a firm and the firm processes CTAPP compliance through the agency billing and you're associated with you've confirmed in writing that you as a licensee are associated with one or more of the trust accounts for that firm, I would get in writing from and the managing partners probably should be sending out an email saying we are in full compliance with CTAPP, so you all can, all the licensees who are connected and associated with the firm's trust accounts can properly do that compliance on their own individual State Bar profiles. And this is actually a very good point. What is the probability of a particular firm being audited? This is not random audits, like random. Everyone's name is in a hat. The audits and the compliance reviews are going to be, and this is according to the report from staff in the recommendations to the Board of Trustees to adopt CTAPP originally. They're based on risk factors. The first and most important risk factor for being subject to a compliance review is area of practice. If you are in a consumer-facing area of practice that holds settlement funds, you're number one on the list. Now, some people, personal injury lawyers, a la Mr. Girardi, for obvious reasons, but you cannot feel safe. Oh, I do employment law. Oh, I do lemon law. That's not going to save you at all because it basically, for the purposes of this kind of analysis, it's consumer-facing law that handles settlements. If your firm and your office handles payout of settlement checks, you're number one on the list. Right behind, basically, personal injury lawyers or variations on that theme are family law lawyers. The reason being, as I've already touched on, a lot of times, family law lawyers will hold a large amount of money, like the sale of the house, hundreds of thousands of dollars, and they don't have it in an individual interest-bearing trust account, which is in itself a problem. But then also there's just a higher risk of harm because of the amount of money involved. So your area of practice is one of the risk factors that helps identify who's going to be audited. Another is the amount of money in the trust account as of the end of the reporting period, which is why, as part of your information on your State Bar profile, you have to report the ending balance as of December 31st. And in the last years, you have to identify at least one area of practice, your main area of practice. Another risk factor is if you've had any insufficient funds activity at all ever on your trust account. So someone that, even if they didn't have discipline from a bounce check in their trust account before, if there was ever an investigation of a reportable action related to insufficient funds activity on your trust account, you're at higher risk of being audited. I would honestly say, based on those risk factors, it's very unlikely large firms, defense firms are going to be facing audit. It's not impossible, but it is very unlikely. And for the purposes of the compliance reviews, it says no less than 1 year of activity. So the expectation is going to be for the reporting period, meaning it would be December to up till December 31st, 2024. That's the reporting period. Now, the screen that's up for you right now, these are the 4 approved CPA firms. In last summer, 2024, the State Bar sought, CPAs throughout the state of California to apply to be on this list and to go through the rigors of, review so that they can get on this list. These are the only approved CPA firms. And while the State Bar says that these audits are going to take between $5,000 and $10,000, others that have been conducting these kind of audits or similar type of audits of trust accounts by CPAs said the cost is probably going to run more like $10,000 to $25,000 based on the kind of work that needs to be done. So 20 law firms a week for 5 weeks are getting the notice. And so it's going to be 100 altogether for this year. And in next year, they plan on doing 400. So they're ramping up. And I think even the folks that are at the Division on Attorney Regulation would agree that 4 CPA firms, that's all that's available. Probably they need to update this list. And also part of their contract with these companies is there's no cap on fees for the work that's being contracted. So that's one of the problems that I think a lot of law firms and lawyers see as being a concern, that this basically, for the purposes of this audit, for which there's been no indicia of any wrongdoing by the lawyer, it's going to cost, even they say at the best, $5,000, $10,000. It could be up to $24,000, $25,000 for this work. Let's go to the next slide. Now, if the compliance review, which is that 12-month period, shows problems, or even just, it doesn't have to have a reason. There's going to be a certain number of compliance reviews, this year 100, but then they have these investigative audits, and these are for up to 3 years of trust account activity. If you're selected for participation in this type of a procedure, you have to do all of those same things. You have to open up on their special portal an account, so you can upload all these, 3 years worth of trust records and your account journals and all of your client ledger cards, et cetera, et cetera. So this is much more in depth. I would imagine this is what's going to be much more like the $25,000 or more cost. Go to the next one. Okay. Yeah, as I already said, there's 5 weeks of these reviews. 100 people are going to be selected and have been. They've been rolling it out. And I've already told you that only if you gross less than 150,000, you can ask for an exemption and have an internal audit done. Let's go to the next slide. Now, part of the reason why there was some delay in rolling out the compliance reviews, which initially the State Bar and through the Division of Attorney Regulation expected to do as soon as the compliance period ended in April, was the fact that there was a lot of hue and cry about these proposed implementation rules. Basically, there are multiple comments about this, these rule changes, these new rules. And the most important issue is that, we have these corrections, the amount of corrections that would be required to get for mandatory reporting or mandatory corrections, corrective action, that was challenged. Also, and this is something that is adopted starting in 2026, you have to have a notice of financial institution form. Pretty much, if you open your trust account anytime since in the last 2 years, you're probably going to have to do this new form, which is basically to directly with the banking institution associate your law firm and your your bar license with that trust account, because up until now that had not been necessary on the financial institution side. Let's go to the next one. So, the special counsel for the Division of Attorney Regulation did make some editorial fixes to these changes. They did talk about the form required by statute, which is, based on, all banking institutions now have to have a licensee's bar number associated with that. You also have to make sure that starting next year, not just your individual trust account, but all your IOLTA and individual trust accounts have this special notice of financial institution form. So that's something that will be a big, push with respect to the new compliance deadline, which is by next April. Next screen. Now, both the LA County Bar's Ethics Committee and others raised concerns, which I think most of you probably have identified as well. This is going to be very expensive for attorneys to comply with, especially since it seems to be targeted at small firms and solo practices. The estimates that we were able to glean would be more like the $10,000 to $25,000 for this work, rather than the $5,000 or $10,000, which the State Bar has suggested. But remember, even though the State Bar said, oh, it should range between $5,000 and $10,000, there are no fee caps on their captive CPAs to do this work. Now, another thing is the timing. Part of what these CPAs are going to be auditing is not just what you would expect, probably, which is that, hey, do these bank statements from the trust account correspond with the account journal that's provided by the lawyer? So if you're using Quicken, if you're using QuickBooks, if you're using Xero for your trust account, you've created an account journal. And an account journal is basically a glorified check register. It identifies by date every single transaction that happens in the account. And the most important part of that is that it identifies each of those transactions with a client or a matter. That way, by running a quick report through your online software, you'll be able to run what's in basically a client ledger card. 25 years ago, the client ledger card was really a hard cardstock card where you would say $5,000 in for a client Jones. Oh, I just paid expert fees of $1,000. Now I have $4,000 left. It was actually a piece of paper or a piece of cardstock. Now, in today's world, with almost any type of trust account, it's going to be a report out of your online software for which you maintain your trust account. I hope you're doing that. Sometimes some people are still with a very, very inactive trust account using Excel. But even there, your client ledger card is really a filter through your account journal, even in Quicken, which will find all the Jones transactions to show when the Jones money was put in, and here's how the Jones money was distributed. So basically, you would think that's what the scope of what this audit is going to be, but that is not true. That's just the beginning of the audit or the compliance review as imagined and as proposed by the Attorney Regulation Division. What's going to happen is once the law firm or licensee has uploaded the trust records, then the CPA that's selected by the law firm, or once the documentation is already uploaded, the selection can be made by staff of the Attorney Regulation Division. They're going to identify a subset of the client matters that are reflected in those bank records, and then ask the lawyers to provide the following. If it's a settlement deposit, like an Allstate check for $100,000 deposited May 1st, 2024, they're going to say, okay, for this May 1st, 2024 Archer deposit, I want to see the Archer fee agreement. I want to see the Archer notice to the client and all the claimants within 14 days that the law firm notified the client and the claimants of the receipt of funds within 14 days, as required under Rule 1.15 D2. And I want to see that the money was completely distributed within 45 days from the date it was deposited or the date it was received, both. It's 45 days from the date you received it. So they're going to see, did you deposit the check timely from when it was received? And if from that deposit, was it distributed within 45 days? And if it wasn't, establish good cause why. Establish that the money was still in dispute, like the face value of the liens until they were resolved. It's still in dispute. It can't be paid out, or other good cause. So, query, why do you need a CPA to do that type of a investigation? And those aren't CPA work. That's really making legal decisions. So that's one thing that the Division of Attorney Regulation is trying to, walk the line on, because they're basically saying, oh, the factual determinations are being made by the CPA, but the legal decisions will be made within the Division of Attorney Regulation about whether or not there's compliance or not with CTAPP and with Rule 1.15. Another major concern about this, a fee agreement is confidential under Business and Professions Code 6149. There's no client complaint here. When a client complains, they've waived the confidentiality. So if they file a bar complaint, the bar can obviously ask for that fee agreement from the lawyer. There's nothing like that here. There's been no waiver. There's not even notice to these clients who have privacy rights in the fact of the retention and all the documentation, all the communications. So that's something that the state bar tried to get around by just saying, oh, attorney-client privilege doesn't apply to these type of documents when they're sought by us. This is something that probably will have to get litigated, because they're basically saying that they can abrogate the most important privilege known in California, attorney-client privilege. And as we've already talked about, the high cost of this and the fact that it's mostly going to be borne by small firms and solos for very little public protection that's going to be discernible, really is going to impact access to justice. Because by putting so much administrative burden on law firms, the smaller cases just won't make any economic sense to be moving forward. Let's go to the next slide. And I already talked about the cost, and we have no idea how much these are really going to cost. Supposedly the bar thinks $5,000 or $10,000, which, by the way, for a small firm, a $10,000 extra cost. And that's just actual fees to the CPA. Don't forget how much extra impact it's going to take on the law firm to comply with all those requests for information and et cetera. That's going to put a very heavy burden on law firms. Let's go to the next one. The time. In many, many cases, especially if you're trying to pay out a settlement, there are reasons that are properly documented and documentable as to why all of the money didn't get distributed within 45 days. If there's a Medi-Cal or Medicare lien, it may take way more than 45 days to finally negotiate and resolve that lien. You have general liens. You have a situation where the client may have moved and then the check didn't get cashed because it never made it to the client. There are endless number of ways. So just saying, oh, if there's non-compliance because of 45 days, it means that there's a lot more analysis that needs to be done. Again, where there's been no complaint. So this is really putting a major burden on lawyers on a regulatory scheme with, I'm not certain that there's going to be much benefit for the public with respect to the adoption of these rules. Let's go to the next one. This is something that really, as I kind of touched on it before, the state bar has completely paid short shrift of the privacy concerns. There are clients that don't want the fact that they had to consult with a lawyer to be made, to be disclosed at all. And there have been Supreme Court case law, which says that when the state bar gets access to confidential information, that they need to be able to provide proper notice to the persons whose information is being sought. The state bar has never, ever taken any action on those authorities. And this may be the time that it becomes necessary to really revisit this issue. Because like I said, the way that they wrote the rules, you could see that it was absolutely intended to be, that they're just saying, oh, no big problem there with this privacy concerns. It is not unusual with respect to in a state bar investigation where there actually has been some type of client complaint or a complaint where, you know, the state bar just doesn't recognize privacy concerns. If the client themselves makes the complaint, obviously, yes, the lawyer has, you know, there's been a waiver. But when a complaint comes from a third party, etc., sometimes the investigator wants things that they're not entitled to. And you as the lawyer have to maintain inviolate any confidences that have been entrusted to you, and more generally under Rule 1.6, maintain privacy over that information that you obtained that's not publicly available by your client that you came in contact with because of that representation. So basically now, in the context of a regulatory scheme, the state bar is like saying, oh, all of that case law, all of that, those privacy concerns can just be brushed aside. That may not be so. So we'll see how that shakes out. That's literally underway now. Let's go to the next one. Yeah, and as I already said, you know, they're going to be seeking your fee agreement. They've already said this. They're going to seek your fee agreement. They're going to seek your communications with the client, you know, about how you talked about the settlement. And here's that case I was talking about, the Doyle case from back in 1982, where it talks about, again, with the Supreme Court getting confidential information, you're supposed to adopt the practice of notifying the non-complaining clients about the records being sought. The state bar has never taken any action on this Doyle advisory or direction. So we'll see if this might be the time for this to come up again. Let's go to the next one. And, you know, for the last several years, the rallying cry of the state bar has been to increase access to justice for underserved communities. All of these additional burdens put on lawyers, especially consumer-facing lawyers that are providing legal services to this populations, really directly impacts that access to justice in a negative way. That's something that the state bar has completely ignored, and nor do they want to have to establish how there's any public protection in these really invasive types of audits that they're going to be undertaking. Let's go to the next one. And the Association of Disciplined Defense Counsel also submitted concerns in writing about these adoptions. So basically, these procedures are pretty much overbroad under the Constitution, and they really are going to undercut the main mission of the bar, which is to increase access to justice. Let's go to the next one. And the review procedures are going to violate the privacy clause of the California Constitution, because they literally are going to be asking for your communications directly with your client, your fee agreement, and without any due process, without any notice to these non-complaining clients that this is underway. And really, it's not even clear how they're going to choose, once they get your bank records, which cases to supposedly audit. It won't probably be all of them, because that would be, way more than even $5,000 or $10,000 or $25,000 worth of cases. But even if, let's say there's 10, how do they pick the 10 cases for the whole year? One law firm that's a boutique firm may only have settled, 3 cases in the entire year. Are they going to audit their entire number of cases? We don't know exactly how this is going to play out. Let's go to the next one. And I can tell you this, this cost shifting provision, basically to put on the backs of these solo and small firm lawyers that are selected for audit, which are going to obviously affect small firms, minority owned firms. The reason why this happened is that the state bar didn't get $180 a head in their request for a fee increase last year, because the state bar wanted to fund more CPA positions so that they can have this, even more expansive CTAPP procedures within the Office of Attorney, or the Division of Attorney Regulation. And because they only got $125 last year, which was, by the way, the largest fee increase in more than a decade, at this point, the state bar has major money problems. Not to get into the inside baseball too much about the state bar, but they sold the building up in San Francisco, and they used that money to fund higher salaries for executive staff that they're now committed to continue to pay. And at that same time, because the wish list amount of additional licensing fees wasn't adopted in Sacramento. Now the state bar office-wide in all the different areas of the state bar has to have a 15% vacancy rate for all of the bargaining unit or union positions, 15% vacancy rate. So even with that, they have a looming deficit coming because of the high salaries that they've already committed to, mostly to executive staff, much higher. I think the executive director makes almost double what the governor makes, like $400 and some odd thousand, by the way. So it's a lot. And they have actually higher number of executive staff now than they did in 2018 when the sections were still part of the state bar. And it was top heavy then. But now the state bar is even more top heavy. So because the state bar didn't get their major increase, even higher than they got, that's why they've adopted, let's shift the cost of these audits on to the practitioners themselves, which is really, just being selected for an audit might be, what puts a law firm into the red for the year, depending on how much their revenue is. So it is very, very expensive process. And it's something that the state bar wants to build on. At 100 this year, 400 next year. And at what, by the way, in my experience, I've consulted with, I would say, dozens, if not hundreds of lawyers since the adoption of CTAPP about how to get into compliance, how to make sure that, to the penny, each law firm knows, where every penny went and belongs. And, many lawyers, the problem was not a bunch of Girardis were uncovered by the adoption of CTAPP. Instead, what happened was many, many lawyers that work very, very hard, delivering quality legal services. The problem was that over the many years they've had a trust account open, there was unaccounted for funds they probably didn't pay themselves because, they're so busy paying out clients, paying out lien holders, etc., and moving on to the next case, getting the next case, doing the work. So there was extra funds, unaccounted for extra funds in those accounts. And now, 3 years into CTAPP, I would hope and expect that most lawyers now have that under control. Hopefully, they know where every dollar belongs, and they've done, taken steps to diligently, get the money out of their trust accounts. That's what's required. If you look at the comment 6 to Rule of Professional Conduct 1.15, it talks about you have a duty as a licensee to diligently distribute funds from your trust account. So it's not enough to okay, I wrote all the checks to get all the Archer money out of the account. You have to follow up with your monthly reconciliations, and then, okay, next month, maybe that check didn't clear. That makes sense. It takes more than 1 month sometimes to clear a check, but 2 or 3 months out, now you have to start taking steps to either reissue the check, make sure the medical provider got the check, put a stop payment on the check. You have to do whatever it takes to make sure that money eventually gets out of the account. But a lot of lawyers had, checks that might be more than 5 years old that never cleared. And that's part of why they weren't in balance. But now that most law firms are in balance, guess what? The interest on trust accounts that goes to the state bar to fund legal services for the poor has gone way down because there's less money in trust accounts. Because when there's accounted for money, lawyers clearly have to take out all their money and they have to promptly distribute to clients. So that has the unintended consequence of making, funds for legal services for the poor a smaller pool. But they did not find a bunch of Girardis because, it's easy for someone that's already stealing $100 million to just go click, click, click and certify CTAPP and hope he never gets audited. But for the hardworking, diligent lawyers, people that would attend this kind of a program, as a matter of fact, you're the ones that can't sleep at night because you couldn't balance down to $1.50 or something. I had people that consulted with me because after doing all the forensic work back 5 years, which is as far back as the state bar can reach, because under Rule of 1.15, you have to maintain records for 5 years from the last disbursement. So the worst case scenario probably is a 5-year audit. And that's how much they can make you provide documentation for, because you have to keep documents for 5 years from the last disbursement. If they're super adamant, they can try to get your bank records back 7 years, because financial institutions need to have records back 7 years. So that's the worst case scenario. But if you've done all the work back 7 years or 5 years, truthfully, and there's still a moribund balance in your account, think about it. Whose money is that? You can't tell. You don't have bank records for it anymore. You can't get bank records for it anymore. And honestly, if it was client money, most people don't wait patiently 7 years. Hey, where's my check? It's a very uncommon situation. So a lot of lawyers have wrestled with those type of issues, not, oh my God, I've been stealing money and now the CTAPP is going to uncover it. So most of all of what this extra burden that the State Bar has put on lawyers is not going to directly address the problem with the kind of complaints that came in against Tom Girardi. Because you don't need CTAPP when a client has complained, I didn't get my settlement and the case settled last year. That is an easy, easy case for the State Bar to prove if they really want to. And they obviously didn't want to for whatever reason. But instead, we have CTAPP. Okay, let's go to the next slide. And okay, the State Bar spent about a year in the vetting procedure to get a CPA law firms, CPA firms, not law firms, on the list. Only 7 made the cut. Like I said, this leads to like major overreach and abuse. As it is, these 4, since there's only 4, are probably going to have to do 25 audits a piece in order to like just get through these 100 for this year. So it's going to cause a big problem with respect to availability of the only 4 CPA firms that can even do these audits according to the State Bar at great expense to licensees. And they're basically being asked to do what would look like legal work well past what a CPA would be necessary for. Let's go to the next one. And you have a copy of these screens. So a lot of questions can be answered by going through the FAQ pages on the State Bar's website about CTAPP in general. You can try the ethics hotline if you want. I don't think it'll help you too much. They have a State Bar Resource Center, and they do have, and you should take, through the state, they have a online class on trust accounting and reconciliations. That is through the e-learning portal of the State Bar. I really strongly recommend you take that class. You do get ethics credit for it, so it's that. There is that, but I do think it's very valuable. So you absolutely should not miss out taking that class. The State Bar also has a over Zoom live 3-hour trust accounting class, which you might want to do. It goes through the trust accounting handbook. And the trust accounting handbook is really an important primer. You should have that as a bookmark on your desktop, because it really provides a lot of information about how to properly handle your trust account. So with that, I'm going to go through some of these questions and make sure that we hit them. And if you have other questions about CTAPP or these compliance reviews, feel free to reach out to me. You can click the next screen. And actually, you could just take down these and I'll go through the questions. You can just take down this is what I would say. If you have questions, go ahead and contact me, and I'll be happy to answer questions. You can email me at erin@erinjoycelaw.com. So I'm looking at a couple of these questions. Okay, if you are a multi-jurisdictional practitioner, let's imagine I'm in New York and in Los Angeles, and I do New York cases. I don't have to administer settlements on my New York cases through a California trust account. However, if I have a California case, I can't put those funds into my New York trust account. And I have to register my trust account in California for sure. So that is something that if you have more questions about that, you can reach out to me. Honestly, I can't tell you what in particular what the 89% non-compliance with would be, but probably things as like, they notified all the claimants within 20 days and not 14 days on each of the 10 cases we audited, something like that. So it looks like the compliance reviews are going to be for the reporting period, January 1st through December 31st, 2024. So that should give you some insight onto that. But they're not limited. And if they start finding non-compliance, they just dig further, is my experience with respect to at least investigations by the State Bar. Okay, I can recommend, if you are not using online software for your trust accounting, you really want to. Some people that, if you do less than 10 transactions a month in your trust account, using Excel is probably okay for you. But anybody else, you should be using, there's QuickBooks Online, which is very user-friendly. They have a lot of tutorials online to help you there. And you may want to get a CPA to get you set up within QuickBooks Online so you can do it yourself. Or I personally like to use a CPA that I meet with every month to go over the reconciliations. You do not have to do the reconciliations yourself, but you have to have hands-on actually reviewing the reconciliations every month to be fully compliant. If you're a transactional practice and deposit unearned retainers into the trust, is this a low risk of audit practice? Maybe so. However, in talking to Steve Moad, the head of the Division of Attorney Regulation, he said if you're an hourly lawyer, transactional practice, the way that they'll do the audit is that they'll pick 2 or 3 deposits, and then they'll ask you to show, hey, here's I want the fee agreement, I want all the billing statements which you billed against those funds, to show how you earned that money in that reporting period. So if you've got like a client in February 2024, deposited $10,000, and they're going to want to see, oh, show me all the invoices for the rest of the year, how you earned any of that $10,000. So this is going to catch lawyers that don't do periodic, like monthly billing. If you do hourly work, you really, really want to make sure that you're doing that. The purpose of this is supposed to achieve, I guess, honestly, the State Bar is generally educates through discipline. So now they're trying to, I guess, create these audits to like of a subset of lawyers so that it creates more compliance throughout the industry as a whole. Will they eventually audit every consumer law firm? I doubt it, because there's so many. There's 250,000 active lawyers in California. They can only scratch the surface of these issues. Is the primary concern that the account is reconciled down to the penny? Yeah, you really need to make sure you are. You do not want to have unaccounted for funds in your trust account, because if you do, how did you properly comply under penalty of perjury that you're in compliance with CTAPP for the last 3 years? I think it's a really big problem if you're not, and I actually have had lawyers talk to me about that. Are calls to the ethics line confidential? They are. They are. Yes. Okay, if you're handling your trust account limited in its manual, I hope manual means at least on Excel. I think the account journal books, like those went by the way of the buggy. Do not be doing it like with those green pages anymore. You have to have it on some kind of online software. How are you going to upload them? I mean, they're going to ask you to upload them. You're going to just take like screenshots of your like book? No, that will already be a problem, because under Rule 1.1, which is your duty of competence, it includes technological competence. That's why, unless you have an ADA accommodation, every lawyer now has to do all of their updating of their State Bar profile electronically, because they want to stop people from relying on paper, basically. Oh, yeah. So, okay. So part of that, let's imagine you have the PI firm. It's going to be fee agreement, notices to client when you got the money, the check. And then it's going to show that the disbursement sheet was paid, was given to the client to give an accounting. Did you properly account? Because that's a duty under 1.15D4. So yes, you're going to have all of those kind of documents. And you're notified about the audit selection through email and through your State Bar profile, because they put communications in your State Bar profile. And then when you have to, and then you do have to notify when you receive funds. It's not just the client that needs notice, it's anyone that has a potential claim on those funds. So if it's a settlement check for the whole case, that's the medical lien holders, that's the ambulance company, that's the litigation funding loan company, that's Medicare or Medi-Cal, and the client. It's all of those things. And the consequences of not being in compliance are kind of unclear and murky. First, it'll be that notice of corrective action, but it absolutely can include referral to the disciplinary arm of the State Bar, the Office of Chief Trial Counsel. So that is basically all the time we have. I really appreciate the opportunity to present to you today on this. This is really an emerging area. There's a lot of changes happening. The FAQs are changed weekly because the Attorney Division of Regulation comes up with new things that they realized they didn't consider initially. So really, even if you read the FAQs before, they're different now. You want to look at them again. Okay, and if you have questions, please reach out to me, Erin Joyce. Thanks so much.